Hi there, welcome everyone to Digital Europe's latest digital deep dive on copyright levies. This is our series where we drill down into some of the hottest topics and some of the topics for which we would like to be the hottest topics in Brussels. And so Digital Europe, if you don't know us, we are the main tech trade association in Brussels. We represent the entire digital sector. We have two chambers actually. 41 national trade associations from all across geographical Europe. And we also have 113 corporate members spanning the whole spectrum of digital. So everything from consumer electronics to cloud services, and also industries which are digitizing, like healthcare, manufacturing, and defense. And so collectively, we represent about 45,000 companies operating in Europe. And so today, this is our deep dive into copyright levies. And so we'll take a look at our latest white paper on copyright levies. And we will kind of drill down into this topic. We'll look at, we'll first of all start with what are copyright levies and what do they cover, what do they not. Then we'll look at, why the system in its current form is outdated and no longer makes sense for Europe. And then we will look a little bit building on the reports of the Draghi and Letta reports on the impact of copyright levies on the single market. Then we'll explore some of the emerging trends that we see across Europe when it comes to copyright levies. So levies on cloud services, on offline downloads from streaming services like Netflix and Spotify. And we'll also look at levies on refurbished products. Then we will discuss some ideas for reform. So we would like to start a debate with stakeholders about reforming this current system. We think it's long overdue, and so we kind of propose some ideas to start that discussion with stakeholders. And we have a great range of speakers today, some experts on copyright levies. So we have Kathrin Bremer from Dell. So she is the chair of our copyright working group here at Digital Europe, and she has tons of experience negotiating copyright levies and dealings with compliance from a manufacturer perspective. We have Stella from AFNUM, who's the Director General of AFNUM, and AFNUM is the French Alliance of Digital Industries. Stella also sits on the Private Copy Commission in France, which is the body in France where you have collecting societies, manufacturers, consumer organizations that negotiates and decides which devices are subject to levies and how much. We also have Pippa Wheeler from HP, who has decades of experience also working on copyright levies and litigation around this topic. She's also the vice chair of our copyright working group here at Digital Europe. And then we have Jean-Marie Le Guen, the Secretary General of Secimavi, which is the French association representing consumer electronics manufacturers. Jean-Marie is also a member of the Private Copy Commission in France, along with Stella. Then we have Markus Scheufele from Bitkom, which is the German Digital Industry Association. And Markus is the head of legal at Bitkom and has lots of experience with the copyright framework in Germany and negotiating on behalf of his members with collecting societies, the levies in Germany. So that's kind of the agenda for today and the speakers. And if you want to ask questions, you can do so in the Q&A function. And you can also feel free to post about this if you would like on using the hashtag Digital Deep Dive. So without further ado, I think I will kind of kick off with a bit of a reminder for people about what are copyright levies, because we work on them day to day, but we realize that a lot of people, either they haven't heard of them or they forgot about them, because it's really been about a decade since they were really on the agenda day to day in Brussels. So what are copyright levies? Well, copyright levies, or private copying levies, you might want to call them as well, are the fees which are imposed on certain consumer electronics and also blank media to compensate rights holders for potential lost revenue from private copying. They were originally introduced in the 1960s in Germany, to compensate authors and artists. And they were a response to developments in technology. So at the time, it was things like tape recorders and photocopiers, which made it easier for consumers to make personal copies of books and music and other copyrighted works without directly paying rights holders royalties or receiving it, getting permission before they made those copies. And so this was introduced as a mechanism to compensate rights holders for those harms. And so that's kind of the history of it. And nowadays this system has expanded from what was originally levies on blank media like blank cassette tapes or CDs, but now this kind of system from the analog era has been expanded and also applies to most consumer electronic devices that have the potential for copying, even if consumers rarely or never use that function. And so it varies a lot across different countries in Europe, but there are 22 countries within the EU right now that have device-based levies. And if you're buying, for example, a smartphone, a laptop, a tablet, a printer, even a games console, or even now we see in some countries virtual reality glasses, that may involve paying a copyright levy. And for example, that could be up to 87 euros when you buy a multifunctional printer in Germany, 18 euros on a games console in Italy, or 14 euros on a smartphone in France. And what do you get for paying this private copy levy? What's covered? So, as I said, they are intended to compensate rights holders for the harm caused by legal private copying done by individual private citizens under the narrow EU private copy exemption. So examples would be photocopying a few pages from a book, or uploading a CD that you have legally purchased onto a personal device like an MP3 player. Yeah. So think about how often you do those kinds of things nowadays. The legal basis in Europe is the Information Society Directive, the InfoSoc Directive from 2001, which Article 5 of the InfoSoc Directive mandates that member states need to put in place a mechanism to compensate artists or rights holders when there is a mechanism for private copying. A common misconception is that levies are there to compensate for illegal copying. That's not the case. It's crucial to note that it's only for legal copies under the private copy exemption. So it's distinct from piracy, like illegal downloading or unauthorized file sharing. The losses from piracy are dealt with not by copyright levies, but other legal mechanisms, anti-piracy laws and penalties for that kind of stuff. And so why does this whole framework matter? Why are we organizing this discussion today, and why have we at Digital Europe published this white paper? Well, copyright levies are an often overlooked piece of the copyright puzzle, which we think is long overdue reform. So as I said, that the legal mechanism for this dates back from 2001, and obviously technology and the way that we consume copyrighted content has changed a lot from 2001. And many stakeholders are unaware of the complexities and the consequences of the system. But according to CSAC, so the International Association representing collecting societies, Europeans are paying over €1 billion in levies each year. So it's a significant sum of money. And so we've organized this webinar to shed a bit of light on the system and its inefficiencies and the broader implications. And at a time when the Draghi and the Letta report have been highlighting how Europe is lagging behind, we think this is an obvious way in which we can reduce the burden for businesses and improve our competitiveness. And we think, although the reforms have been long overdue, and we've seen promises from the Commission, the Parliament, and the Council over many decades to reform the system, we haven't seen that so far, but we're optimistic that with the new Commission, there's an opportunity. we want to put it back on the agenda and have this conversation with rights holders, with consumer organizations, with policymakers about what an alternative system could look like. And we're optimistic that now when we have an executive vice president in charge of tech policy from Finland, who understands this topic well and has worked on it in the past, and also coming from Finland, we think that that's a model that could work very differently. We'll talk a little bit more about that today. And great that we've had over 200 people register for this event. So although it's not widely discussed in Brussels, clearly across Europe, there's a large interest in learning more about it. So what I'll do now is I will pass over to Kathrin from Dell, who's going to talk a little bit more about how the system works now and why we think the system is out of date.
Okay, thank you. As Hugh already mentioned, and before going to this overview regarding how private copying behavior is today, let's go back just for a second to the 60s when the system was invented. As Hugh already said, the devices were used by private users for copying, and only for copying. And this totally changed during the years, because now not only private users are using the devices, and the kind of the devices totally differs. So when entering in the digital age, the traditional separation between, recording devices and playback devices disappeared. So multifunctional devices entered the market, which you use for private copying or copying and other purposes. So the copying function was more and more only a secondary function of the device. And further, when the system was invented in the 60s, no licensing models existed in parallel. And that was one of the reasons why it was said we need the compensation system by levy the device. So the situation was totally different 60 years ago. And now back in reality, and beside these technical developments, one main reason why the system, from our point of view, no longer makes sense is that the copying behavior totally changed. So if you see this overview, you can see that it's from the Finnish government, because they are doing user studies every year to analyze the private copying behavior, it's decreased enormously over the years. So today it's less than half what it was 10 years ago. And why does it change that drastically? I think we all know the behavior is different. So in the past, users made private copies to have a second version for the family members or for using, for example, a music CD in the car. Today, there is no need anymore to do a copy, because users subscribe to streaming services. And instead of making a copy, the whole family, for example, is subscribed to the service, and everyone has access to the service, and no copy is needed anymore. And that shows that the system doesn't align anymore with the current user habits today. So you could ask, why does it matter? And one key issue why it matters is that it follows to an unjust tax on consumers. So that means the consumer, because of this different usage behavior today, he pays double. So he pays first for he pays the streaming subscription fee, and in addition, he pays for the device. And he doesn't pay only for one device, but he pays for PCs, tablets, smartphones, external hard drives, etc. So for many devices, although he is not copying anymore. So this system foreseen by the InfoSoc directive and this basic principle enshrined that the levy should be calculated on the basis of the harm caused to the right holders is totally overridden. And then there is one other issue why, from our point of view, this system needs to be reformed, and that's the unfair impact on the business. So I said the situation is totally different in the past, where the devices were only used by private users, private persons, and today many of the devices are also used in the commercial sector. So having this in mind already in the directive, and so in EU law, it is foreseen that only natural persons are allowed to make the private copies. So the ECJ clearly stated that the exemption of the exclusive rights of the rights holders must not be applied to others than natural persons and for other purposes than private copying. So that means that devices and media used in the business sector shouldn't be levied. And even further, the ECJ confirmed that if it's clear that it's not used for private copying in the commercial sector, the professional user should be exempted upfront. And only if that's not possible and a collection is unavoidable because it's too burdensome, then an efficient and easily accessible reimbursement system should be applied, but only as a second best solution. So far, so good, but the reality is totally different. So we have the situation that in many member states, the levies are collected unlawfully from all professional customers, and they are not exempted upfront. So if you have in mind that, for example, a device like the PC is used around about 50% in the commercial sector, where no copies are made, it's obvious that it's unjustified to levy all the devices shipped to the market. But nevertheless, it's quite often done. And in some member states where we have reimbursement systems in place, the big problem is that they are so burdensome and complicated and expensive that they are almost not used. So you can see the overview here. And for example, in France, only 1% of the amount what should be reimbursed is reimbursed. And that's similar in some other countries. And we have even some countries where, for example, in Poland, where from what we know, nothing is reimbursed because the system in reality doesn't exist. And the consequences are that you have an unfair impact on the business sector. And this concerns in particular SMEs. They suffer significantly from the current levy system. Many of them are not selling these devices in the consumer sector. Nevertheless, they have this burden, and this burden often goes up above 5,000 euro. So that's a really huge impact for them. Further, we have a lack of transparency and accountability. So we have just learned around about 1 billion euros are collected and they are distributed to the right holders. But often, not always, but often it's unclear how these funds are used, how they are distributed, how efficient the market coverage is, and if it's not, what is being done to combat the gray market, which is a big problem in this international business world, and how much is reimbursed. And then normally there are user studies to assess the usage behavior done by collecting societies, but sometimes they are not public. But that's the base for calculating the levy. So the question is, why is this not transparent? And this should definitely be changed. So you could say, nevertheless, these are maybe points to adjust the system, but if the system would be a good deal for the right holder, shouldn't we keep it? And from our point of view, this deal is not good for the right holder. Having in mind where we come from 60 years ago, there was a reason to implement the system. But today, as shown, the world is totally different. But the system which is still in place with all this complication just shown comes to or brings the consequences that huge resources are needed to negotiate the agreements, to evaluate the tariffs and recalculate it. Many studies are done in all countries. There is a different base how to do this. And so lawsuits are ongoing. So this is the fact that the resources used for this impact negatively the right holders, because normally this should be distributed to the right holders, but that's not. So clearly saying the right holder must be compensated if a private copy is done. But as shown, the old device-based system isn't fit anymore for the digital world.
Thanks, Kathrin. I just had maybe a couple of follow-up questions there for you. One is why do you think private copying is declines so drastically? And then when you talk about professional users, what are the devices that businesses are using? And what would be the way that we could simplify the reimbursement or simplify the process to avoid, even in the first place, those businesses paying the levies, which they're not supposed to do? Are there any good examples from other countries?
So, as said, the private copying is going down because it's not needed anymore. Yeah. So in the past it was needed because you didn't want to buy, for example, a CD 10 times or 5 times. 10 times wouldn't be allowed to make a copy, but that's not needed anymore. So that's the reason why it's totally changed. If you stream services, there is no need for making a copy. And on the question on the business, imagine, for example, where the PC, we are using the PC now for this web meeting. Maybe some of us use it also for streaming. Maybe some use it for put copies on. Most of it, I think, is if we have, for example, photos from vacation or something like that. So my own photos, but this is totally different to a private copy, which needs to be compensated because it's mine. But further, these tablets or PCs are also used in manufacturing business. Look, in the restaurants, they have tablets to take your reservation and to take your meal and so on. These devices will be never used for private copying. So why should you pay a levy for this? And on the question on reimbursement, to be honest, it's really difficult to improve the system. It could definitely be easier, but all attempts we did in the countries where the system is in place to explain governments it should be easier didn't work. And we have complicated systems where we are asked to provide all the invoices, declarations, which is really complicated, in particular having in mind that we have this big market where it's shipped from one market to the others, then you have export issues and so on. So it's really complicated.
Okay. Thanks, Kathrin. Now I think we will turn to Stella from AFNUM to talk about kind of the hot topic right now, which is the single market and the impact that copyright levies have on the single market. So over to you, Stella.
Well, thank you very much, Hugh, and good afternoon, everyone. Thank you for being here with us for this webinar on private copying levies. You talked about it, Hugh. The recent reports by Draghi and Letta actually highlight that Europe is lagging behind the US and China. And these reports call for reforms to strengthen the single market, drive innovation, boost competitiveness. So reforming copyright levies is a prime example of where we can reduce burdens for European businesses and improve the efficiency of the single market. So during this webinar, we will demonstrate how the fragmentation of copyright levy systems throughout Europe acts as a barrier today to the European single market and represents a burden, as Kathrin also pointed out, to the businesses, waste of time, resources for all stakeholders. So it's time and resources that we don't give to competitiveness, for instance, or innovation. So you will realize that there are quite some challenges we face in view of harmonizing and simplifying the European private copying system. So what I want to point out is that in Europe, copyright levies are different from one country to the other in many ways. So not only all European countries apply copyright levies, but when they do it very differently across each member state. For instance, you have the products that the levies are applied to are not forcibly the same. The way the copyright levies are calculated is not necessarily the same either. The level of levies applied to the same product across member state is not the same, and we will see there are huge differences. Kathrin talked about it, but there's also the way reimbursements are done, which is very different. Reimbursement for professional uses, but also in case of re-export of goods. And last but not least, the governance of tariff setting is not the same throughout Europe. So, of course, all of these differences represent a strong burden for businesses because they must navigate in Europe with varying different tariff levels, and administrative procedures. And this, of course, again, represents a waste of time and resources. Just to give you a very quick example of what I mean here in terms of burden for businesses, if you take the example of Greece, a company selling several devices may receive up to 72 different private copying invoices from 18 different collecting society every quarter. Of course, it's not an example, luckily, that applies to all member states, but in any case, there are some where the burden is really, really important for businesses. If we take also the way this differentiated system of copyrights impacts the efficiency of compensation, there are two examples that we can give. First of all, there have been a lot of court proceedings, and which are still ongoing for some of them, often during more than a decade. And many court cases end up being referred to the European Court of Justice in order to be decided. So these legal battles actually create a lot of uncertainty and insecurity for companies. And often businesses are obliged to set aside accruals in case retroactive claims come out of these court proceedings. Another inefficiency is often the cost of collection, distribution, and control of the levies are higher than the levy itself. So Austria, for instance, the Chamber of Commerce of Austria made a study, and they actually demonstrated that implementing a 2.5 euros levy on smartphones actually costed 11 euros to the businesses that had to apply it. So this is the general picture, but let's dive into more detailed description of the fragmentation and differences that we have in Europe when we deal with copyright levies. The first thing I told you is not all countries, not all member states pay actually copyright levies. For instance, if we take some Eastern European countries, or Monaco, Luxembourg, Ireland, Andorra, Cyprus, Malta, they don't pay, or they don't have a system. I mean, they recognize the existence of a private copy exception, but they do not have a system in place to collect and redistribute this money. So in fact, there are no copyright levies, but these countries, of course, are neighbor to other countries where the copyright levies apply. And of course, this causes discrepancies and maybe also gray market cases. Also, I told you that in the European countries that do apply copyright levies, well, they're not forcibly applied to the same kind of electronic devices. So if in general, most countries apply levies actually to smartphones, tablets, hard disk drives, only some of them have decided, for instance, to levy smartwatches, game consoles, printers, or TVs. Moreover, some countries have decided to perceive copyright levies on refurbished products, while others don't. Another difference is in the calculation mode of copyright levies. And here we have two different, at least, systems, Some countries have decided to levy taking a percentage of the selling price of the products, while other countries have a fixed price system where fixed, it means one number, one payment can be applied to all storage capacities of one product, but it can also be fixed, but vary following the storage capacity. So we have different systems. And this applies also to VAT, because in some countries, actually, VAT is submitted to, the levies are submitted to VAT, while in other countries they aren't. Actually, there is a decision of the European Court of Justice that maintains that VAT should not be applied to copyright levies because they represent the compensation of a prejudice and not the payment for goods or services. But still in France, for instance, a VAT is applied to copyright levies, which makes it so if we take the average sum that was roughly 300 million euros raised every year with copyright levies, this means that there are 50 million euros going to the state for VAT. If we take now the level of levies, I told you it can be very different throughout Europe. Just a simple example, if we take a 128 gigabyte smartphone, the levy costs €3.25 in Spain, but 14 euros in France and 15,50 in Portugal. So France and Portugal are both neighboring countries to Spain. And you can understand there is a big difference and tendency, of course, to uneven playing fields between these countries. Another example that goes in the sense that what Kathrin was talking to you about reimbursement of professional fees is the case where one country re-exports goods. So what happens is private copying levies are paid by the importer once the goods that are submitted to them enter country number 1, okay? But if these goods are subsequently re-exported from country number 1 to country number 2, well, they have to repay levies when they enter country number 2. And normally, I should get the reimbursement from country number 1. But the problem is that the system is so complex, and with thousands of cross-border transactions each year, practically this makes the reimbursement unmanageable. So we still have a lot of money that remains in the hands of the collecting society as a form of, unjust payment. Last but not least, if we look at the way the tariffs are decided, the governance can be very different from one European country to the other. So some countries have adopted, for instance, a direct negotiation system between stakeholders. This is the case of France, Germany, the Netherlands, Austria, amongst others. That means that there are commissions, for instance, in France, there is a private copying commission where the stakeholders, rights holders on the one hand, industry representative on the other hand, and consumer representatives in some case, it is the case of France, debate together in order to fix these tariffs. In other European countries, levies are decided by the government through a ministry or a designated body. And finally, there are also systems, and it's typically the Finnish case, that are state-funded. That is to say that the levies are not device-based, they're not taken on the devices themselves, but they are replaced by a state fund decided by an advisory board. So this brief overall of the differences in treatment of copyright levies across member states gives you an idea of how such differences distort actually the single market. Products subject to levies in one member state may be exempt in another, we saw it, and this leads to disparities in prices and consumer choices. Businesses operating in member states with lower or no levies at all, of course, gain a competitive advantage, and this creates an uneven playing field and promotes grey market, as we said. where some countries can bypass levies completely, and this results in an unfair competition and reduced income for rights holders. So after this brief overall view, let me give the word back to Hugh Kirk of Digital Europe, who will introduce the emerging trends in copyright levies. Thank you very much.
Thanks, Stella, for that very comprehensive overview and the impact on the single market. Yeah, it's clear that it really is creating a nightmare for businesses trying to navigate this system. And I see in the chat we've received a few questions. One about ongoing court cases, and we'll touch on about them now. Some of the ECJ cases. So the emerging trends that we see across Europe is that despite this system being, what we would consider fundamentally outdated and unsuitable for the digital age, we see a continued push to expand the system and add levies to new kind of media or new forms of technology. And in our view, this would only exacerbate the existing problems even further. And one of the big recent developments that we've seen is on cloud levies. So the recent ECJ case, the Austro-Meccana versus Strasso ruling in 2022, which deals with cloud services, has opened the door for collecting societies across Europe to push for levies to be added to the cloud. And so that's one of the emerging trends that we see in the copyright levies world. And for example, since that case, we've seen concrete demands in lots of different countries, both within the EU and actually within the wider economic area. So in Switzerland, for example, in 2021, the collecting societies proposed a levy of 10.8 Swiss francs, or about 11 euros per user per year. In Germany, following the ECJ ruling, there have been several recent court cases in Germany trying to get data on how many cloud services were imported into Germany. And those court cases so far have been rejected in Germany by the courts. So there's now been demands from rights holders to change the German copyright law to allow cloud levies. And we've seen also in France intense discussions in the Private Copy Commission in recent months. And as a result of that, now there is a user study in France that's going to happen on how consumers use cloud services. And in our view, there's no basis to extend this system to cloud services. I think one of the misunderstandings is how cloud services are used by private individuals. So the main way that private individuals use cloud services is to back up their personal content, things like photos or their documents. It's not widespread copying of third-party copyrighted content. In fact, the Eurostat data confirms this, that the most individual users use the cloud services to back up personal photos and also, personal documents, CVs, the kind of things that, think about what you store in your iCloud or something. And then if in the rare case there are private copies in the cloud, in people's personal cloud, those have already been compensated for by the levies on the devices used to access the cloud. So, your smartphone or your laptop. So if we were to add additional levies onto cloud services, say, or to subscriptions, that would result in an additional payment by consumers. So it would be a double payment, but there is no additional harm to rights holders. So that's why we think fundamentally it shouldn't be introduced. And I think we have to think about, how does this fit into the wider framework? So we're allowing this, this system from 20, 30 years ago to continue and expand naturally without any kind of, we haven't had a proper review or a sense check in a long time. I mean, there's a question about what would adding copyright levies to cloud services actually mean. One, it would raise the prices for consumers, and it would also deter cloud adoption. Because in situations where you have a free model, how would you be able to do that? Go forward if you have to charge a levy on top. So it would deter cloud adoption, which is one of the EU's key digital goals. I think also it would create a grey market in Europe, because European cloud providers would be disproportionately hit by those cloud levies. Enforcement would focus on European cloud service providers and those services also established in the EU, while some cloud services from third countries would still remain accessible to EU consumers who may never pay a levy. So there would be a real grey market issue there as well. And then if we think practically how we would apply cloud levies, like this would be administratively so complex. I mean, what we would be doing is then adding all this complexity that you see with devices and the issues that importers and distributors of consumer electronics have also to the world of cloud. I mean, there'd be a question about geographically where this levy would be paid. Would it be the location of the user or the server? How would you deal with complex situations where you know, an account is used cross-border? A lot of people have family accounts where they may kind of collaborate with, you know, family members residing in different EU countries. How would you introduce a system there to fix that complex question? And then also, the vast majority of cloud services are used by professional users and enterprise services, which are all outside of the scope of private copying levies, because they're not allowed to make private copies. So cloud service providers also have kind of a limited insight in how their users are using the services there, the customers are. And so to ensure that professional users are not captured and businesses are not captured by, you know, cloud services, you would need to then introduce in each member state an exemption system or reimbursement system for professional users. And practically, if you're a CEO of a European cloud service provider, this whole system, which is hanging over their head right now since this ECJ ruling in 2022, and because there hasn't been any guidance from the Commission and no one has stepped in to solve this, you have lots of questions now about whether you really want to expand into another European markets. The questions would be, for example, how and what data would you have to report to the hundreds of collecting societies across the 22 member states with levy systems in place? And also, how would you calculate the criteria for your prices when there are completely different processes for calculating levies in different countries? And what is the risk of tariffs being changed or retroactive claims? Because we've seen in some countries claims for, you know, back payments of up to 10 years for devices, levies on devices in some European countries, even in the last few years. So these would be all the kinds of questions that European cloud services or cloud services wanting to operate in Europe would face from this emerging trend that we have seen in the last couple of years. So that's one of the hottest topics, I would say, around cloud levy or around copyright levies. And then I'll pass on to now Pippa Wheeler from Dell to talk about another area which we see, which is around offline downloads from streaming services.
Thank you, Hugh. I should just clarify that I'm not working for Dell. I've been working for HP for nearly the last 30 years. So, so that's that. Thank you for the opportunity to participate here. One of the questions that Hugh also mentioned is this issue of offline downloads in streaming services. I'm sure many of you are very familiar with Spotify and other offerings that enable you to purchase access to music or other services, films, etc., and also to be able to watch them, whereas previously one would, a long time ago, went to the cinema, or that you bought a CD or a DVD, and you now have the opportunity to view this content, this copyrighted content, on your mobile phone or on your PC or tablet. In order to benefit from using such a service, you have to pay. It's a license model, And many of these license models additionally offer the opportunity to be able to download that content and to be able to view it when it's offline. And these offline contents are referred to as offline downloads or tethered downloads. The reason why they're called tethered downloads is because they're tied to the streaming license that you have signed up and are paying for. In various countries, there is an appetite by different collection societies claiming that these tethered downloads are in fact private copies, which trigger a right to compensation. We disagree with that for a number of reasons. Firstly, these services are being provided as part of a commercial service. Secondly, if you are able to use them, that is because you have paid for them, and your access to that content is only viable as long as you are still a member of that streaming service. So you have to, for example, your phone has to connect to the internet regularly to update it to make sure that you still have access rights to be able to see that content. Otherwise, it will disappear from your device. There are a number of court cases ongoing, and one in particular I would draw your attention to is a reference now to the Court of Justice from the Cassation Court in the Netherlands to examine this question about whether these tethered downloads are in fact private copies. And from the way that it's presented to the court and the decisions that have been made in the lower courts in the Netherlands reinforces our view that these are not private copies and they do not trigger a right to compensation.
Thanks, Pippa. Maybe if you could, in one or two words, if you could just sum up why offline downloads from streaming services are different from private copies. I know you touched about it briefly, but
sure, I'll try and do that. So, if you think about it, when this whole idea of private copying came out in the 1960s, we were talking about a tape recorder. You would hold the microphone of your tape recorder next to the radio and try and tape something and listen to it. That has now progressed to be making different copies. So, for example, of copying a CD, insofar as it's not copy protected, and we must remember, of course, that when something is copy protected, any copy that's made of it, whether it's ripped or however that's made, that is an illegal copy, and there is no illegal copies are illegal, and there is no right to compensation for such illegal copies. The whole private copying exception is intended to ensure that the copyright holder receives fair compensation for the statutory exception to their exclusive copyright in it. So what we have with these offline copies is that they are linked to your streaming service, and as such, they are not permanent copies on your device. They are not, in fact, if you like it, copies. They are part of the streaming service that you are entitled to continue to listen to them whilst you're offline. Does that answer?
Yeah, I think so. Thanks, Pippa. Thanks. And so then maybe one of the other hot topics that we see or recent developments that we've seen in a lot of countries is around refurbished products and how levies may apply to them. And so I'll pass over now to Jean-Marie from Secimavi in France, who will give us a bit of an update on refurbished products.
Yeah, thank you, Hugh. As everybody knows, the refurbishment market is growing quite fast, especially in our market, in our industry. And this is quite a new trend because it didn't exist quite a few years ago. And when the copyright model was adapted to analog market, in the digital and especially in the refurbished markets, it's no longer relevant as we believe, or as is. first, you have to consider that right now it's also a patchwork of legislations when it comes to refurbished products in Europe. Some countries do have levies on refurbished products, but even among those, there are significant differences on the models and the type of device that's subject to copyright levies, or even the rate of the levies. And in most countries, there is no no copyright levies on refurbished products. The other point is, as been said, it is quite a significant administrative burden on companies. And in the refurbishment market, it is quite important, because these companies are sometimes pure players or even not-for-profit players who don't have the resources to deal with such administrative burdens to begin with. Also, you have to consider that when the first product, the original product, has been already levied, then if you have levies on the refurbished product, that would somehow imply that the same product could be levied twice. And as we said, when it comes to the exports of products, there has to be, by law, some sort of reimbursement process for the products. Probably it should be the case also for refurbished products. And actually, it does somehow exist in one country when it comes to not refurbished products, but remanufactured products, where you have to be able to be reimbursed of the cost of the copyright on the original parts that you use. And last, you also have to consider that refurbished products have a different price dynamics on the market compared to new products. Essentially, new products have the same prices all over one particular country, one particular market, when the same product, when refurbished, could have different prices depending on the state, the grading of the product itself, and also its price can evolve over time. So having somehow a fixed levy, as Stella explained earlier, it wouldn't make sense for refurbished products, because it would be more significant for low-end or entry price models compared to higher prices models. So that's basically the case why we do consider there has to be some sort of reflection about the refurbished products and copyright, because what we see also is that the EU as a whole does have a goal, an objective to develop more sustainable practices, more sustainable businesses, and many market players in our industries are making efforts and investing continuously to develop more sustainable practices. So there has to be some sort of consideration of this and how copyright should evolve to help this transition.
Thanks, Jean-Marie. Yeah, I mean, it definitely feels like it's contrary to Europe's ambitions and particularly when it comes to circular economy, to more reuse and repair and refurbishment of consumer electronics, reducing the amount of e-waste that we see. I see in the questions that we have a question about in which countries apart from the Netherlands are tethered downloads currently taken into account when deciding the level of compensation to be paid. So I think the Netherlands, and feel free, Pippa or others, to complement this, but I think the Netherlands is the only country where they explicitly used tethered downloads in the calculations, and so that's why there is a court case. But there is an implicit assumption from collecting societies in other geographies or other member states that this should be compensated for via the levy system. Is that correct, Pippa?
That is correct, yes.
Thanks. All right then, so now we've discussed kind of what we think is wrong with the system. And as I said at the start, we want to start a debate and a discussion, with rights holders, collecting societies, consumer organizations, with policymakers about alternative systems and alternative solutions. So I'll pass on to Markus from Bitkom to talk a little bit more about what we think could be potentially alternative solutions.
Yeah, thank you for the opportunity to speak on a crucial topic in today's webinar, alternatives to the current copyright levy system. But let me begin by emphasizing that compensation for creators in cases of harm, from our point of view, is non-negotiable. No one disputes the importance of ensuring that authors and artists are appropriately compensated when their works are copied under the exceptions and limitations of the Infosoc directive, and they suffer harm as a result. A vibrant cultural sector is crucial for European identity and the success of the European digital ecosystem. But however, as we have already seen today, the current system, which is based on device-based copyright levies, creates significant problems for all parties involved. It's, as we have seen, inefficient, inequitable, and ill-suited to the realities of the digital age. And that's why it's essential for us to consider future-proof alternatives that ensure fair, regular, and appropriate remuneration for creators while addressing existing problems in the single market. These alternative systems should adhere to a few key principles. They must be product and technology neutral, fostering innovation rather than stifling it. Compensation for creators should be calculated regularly and transparently based on actual harm suffered and financed directly or indirectly by the user. The system must not create market distortions, ensuring fair competition across all sectors. And finally, the collection of these funds must be cost efficient and their distribution predictable and fair. Above all, this isn't about claiming to have all the answers. These models represent starting points for discussion, as you stated, a basis for refining and designing a system that works for everyone in the long term. So now take a look at some possible alternatives. As you can see here, 3 of them. A first alternative is the direct licensing model. This approach replaces the existing private copying exception with a system that ensures right holders receive direct payments for each private copy made. Technologies like blockchain could play a key role here, using smart contracts to automate payments based on transparent usage data. What makes this model appealing is its clarity and fairness. Authors would be paid directly on a pay-per-click or pay-per-copy basis, eliminating the guesswork and inefficiencies of the levy system. By integrating blockchain, we can also enhance transparency, ensuring creators and users alike can trust the process. The second model we show here is the household cultural contribution, which offers a different approach. Instead of levying fees on individual devices, this model introduces a small, regular contribution from households. For example, across the EU, a contribution of just 42 euro cent, so 0.42 euro per month per household, could generate 1 billion euro annually. This ensures a stable revenue stream while spreading the cost across users more equitably. This approach ensures that end users who are responsible for private copying pay for it, aligning with the ECJ case law. It simplifies administration and allows for exemptions in hardship situations, which are not possible under device-based levies. And moreover, it leverages existing infrastructures for efficient collection and distribution, making it a cost-effective alternative. By ensuring that all households pay fairly, this model addresses many of the inefficiencies and injustices of the current system. Next is the idea of applying a fee on cultural works at the point of sale. Under this system, fees are collected when copyrighted works, such as digital downloads or physical media, like Hugh mentioned, books, CDs, and so on, are sold. This aligns the financing of compensation directly with the consumption of copyrighted content. If the work cannot be copied due to technical protection measures, or if the reproduction has no independent relevant economic value for the rights holder, then no fee is charged. This model is directly tied to the work itself, ensuring that fees are only applied to content potentially used by consumers for permission-free use under the copyright private copying exception. And this approach ensures proportionality. Those who benefit most from private copying contribute the most. By integrating this system with existing VAT collection mechanisms, we can streamline the process, making it efficient and easy to administer. And finally, let's take a look at the state budget model as implemented, for example, in Finland. Yeah, thanks. Stella mentioned this before. This model has gained attention for its simplicity and effectiveness. After reviewing the inefficiency and unfairness of the device-based levy system, Finland decided in 2014 to implement a better system. Instead of levies, Finland compensates private copying through a fund financed by the state budget. An advisory board supported by annual independent research studies determines the fund size and distribution based on actual usage data. The results of the independent usage studies are published on the website of the Ministry of Culture in Finland. Hanna Virkkunen, designated EU Digitization Commissioner, like Hugh mentioned it before or at the beginning, praised the model in 2014, and at that time she was still an MEP, calling it fairer to consumers and better for artists because they will get more compensation this way. Indeed, this system shifts the focus from taxing technology to directly supporting the creative ecosystem. This system is somehow the other models offers several critical advantages. Fairness and transparency. Payments are determined using neutral and published studies, ensuring both creators and consumers understand the process. Efficiency, by removing the need for device-based levies, this model significantly reduces administrative costs. And reliability, creators receive predictable payments. Finland's approach is also perfectly in line with the EU's wider objectives of promoting a single market. By reducing fragmentation and simplifying cross-border trade, it creates a more competitive environment for businesses while ensuring creators are fairly compensated. The transition to this model would require careful planning, particularly with regard to the financing mechanisms. If the financing is provided by the state, a portion of the budget can be set aside. Earmarking this portion of the budget in the respective national copyright law would ensure that distributions cannot be randomly reduced. So in conclusion, as has been mentioned several times today, the current copyright levy system is a relic of bygone era. Its inefficient, fragmented, and out of step with modern consumer habits. The alternatives we explored today each offer a vision how we can move forward. And as I mentioned at the outset, we do not claim to have a monopoly on the truth. These models are starting points for broader discussion. And discussion, in our point of view, that must involve all stakeholders to ensure a system that serves everyone's interest in the digital age. So thank you for your attention and look forward to your thoughts and questions in the Q&A. And with that, I'll pass it back to you, Hugh.
Thanks, Markus. And for what I understand, actually, also Finland isn't the only country in Europe that has that model. So Norway and Iceland also have a state budget model where they fund rights holders or compensate rights holders for private copying that way as well. So it's just very similar to the Finnish model. I see there was a question in the chat about refurbished products, well, refurbished media. So just to clarify, the refurbishment, it's refurbished devices. So, you know, smartphones, tablets, laptops that are being subject to copyright levies for a second time. It's not refurbished media that's owned by another that already owned by an individual. It's the devices which are being subject to levies, and usually it's done at a discounted rate. So I'm not sure what was the agreement in France, Jean-Marie, but it was maybe 50% of the original levy or something similar to that, if I'm not mistaken, right, Jean-Marie?
It actually depends on the type of device. Only smartphones and tablet, refurbished smartphones and refurbished tablets are subject to levies, and the ratio versus new products differ depending on the type of device. It's 65 or 70%.
Thanks, Jean-Marie. And I know it is slightly different in different countries. So I think they also have refurbished levies on refurbished products. Definitely in Belgium and also in Germany, I believe, but it's also up for debate in other countries.
Yeah, actually in Belgium, in Netherlands, they have the same ratio of 60% applying to refurbished products. And the situation in Germany is quite different because the refurbished products that are subject to levies are only CD burners and hard drives, refurbished hard drives and smartwatches. So the situation is kind of different. And here again, it is a patchwork of a market, which complexifies greatly the opportunity for companies to operate within the single market.
Thanks, Jean-Marie. So I see a few questions now in the chat about the state budget model. One referring to the fact that Spain used to have a state budget model and then they went back to a device-based model when it was challenged. But from my understanding is that the Spanish model could have been tweaked. So it came from the general budget in Spain, and so it wasn't properly linked to private copying. But if it had been tweaked, for example, along the line of the Finnish model, so which it comes from the cultural budget, where there is a stronger link to consumption or private copying and harm, then the model could have stayed in place. I don't know if any other panelists want to speak a little bit more about that. I also see a question in the chat about the current changes or discussions that are happening in Finland. So someone put the budget is going to be reduced in Finland for the state budget for the model. And what's happening in Finland is that so they've had that system, the state budget fund, in place now for 10 years, and every year there has been a decline in private copying, and that's been backed up by the usage studies which are published by the ministry, and you can see those on the ministry's website. And actually, we had it on the slide at the start. But there was never a reduction in the budget each year to compensate or to reflect the fact that private copying had gone down in Finland. So the system which was in place was kind of, you could say, was generously overpaying rights holders, because it was never being reduced down in line with the actual amount of private copying that was going on in Finland. And so I think now, with a new government in place, there have been questions about whether they can support this system or the level of payment. And so it's now being reduced to reflect the level of private copying, but perhaps it should have been gone down in a little bit more of an incremental basis, because every year private copying has been going down according to the stats in Finland. But now there is also a study ongoing in Finland on the status quo. I'm just looking now at other questions.
Just to add to that point that you were making, Hugh, I think that is part of the general misconception, is that copyright levies are intended to compensate. That is the whole purpose of them, to compensate for damage that is suffered by the copyright holder because of the statutory exception to their exclusive rights. It was developed in a time when there was no other way to do it. We're talking about the 1960s. Many of you weren't even born then. This is a completely different time. This is a time where copyright holders are in a position, through collecting societies or also on their own, to negotiate how their copyrighted works are used lawfully and to achieve compensation for the same. And therefore it is appropriate that we go with the technical changes and don't adhere to an outdated, outmoded system and merely argue, oh, if it goes down, that means that people are getting less where they should be getting more. There are fewer devices being sold, but there is, most significantly, less content being consumed by copying, because the world has moved to different technological methods of consuming copyrighted and other content, for which compensation is already being paid through a different route. Thank you.
Thanks, Pippa. And then, yeah, I see in the Q&A function a comment on the Spanish model, and so the system was struck down by the ECJ because the compensation had come from the state budget, and so there was no exemption for professional users. And so one way you could tweak that would to take it from VAT revenues or something like that. And so, as I said, the system in Spain could have been tweaked to make sure it was in line with European law. They didn't need to go and revert back to the device-based levies. And as we've seen in Finland now, they've had a state budget model for 10 years successfully. And we have another question from Inbar, who asks, saying that Digital Europe raised this issue on copyright levies in 2019 in the previous mandate, and how was the response then, and how do you expect the response to be different now? So this is actually Digital Europe's longest running file. Digital Europe's 25 years old this year, and we've been banging the drum on copyright levies and reform for a long time. I think for us, we hope this situation will be different now. Well, one, because we have a new change of leadership, and one that really understands this topic well, and one comes from a country, an EVP that comes from a country that has an alternative system. But also, just I think now it's really very hard to justify the current system when there's been such a change in the way that users consume copyrighted content. Maybe in 2019 there was higher private copying, but now, I mean, the vast majority of consumers, they're paying for streaming services like Spotify or Amazon Prime or Netflix. And so they are directly paying for, directly paying rights holders via the licensing agreements that those streaming services have in place. And there is now no harm for rights holders. So it's hard to justify the system anymore, frankly. And so we're hoping that now, when we raise this issue, that we're going to get a better response. And that's why we've organized this webinar today as well, to put it back on the agenda. And we hope that, as a minimum, the Commission can launch a study on the impacts of copyright levies on the single market. But we know that rights holders right now, they receive a lot of revenue from this system. And so we don't want to, take it away overnight. We want to find a fairer solution, and one that works better in the long term for them as well. And that's why we're open to discussing this, and we don't think we have all the solutions, but we can't just ignore the problem any longer, is what I would say. Trying to read the questions here as well. I don't know if any other panelists want to add anything, or if they see any questions that they want to answer.
Hugh, just quickly, in the chat, someone mentioned that actually the rate in the Netherlands is 40% of the original tariff. Actually, yeah, my mistake. I mistook the 60-40%, put it the other way around. But the point is that, again, what should be considered is that it's a patchwork in Europe, and there has to be a discussion about whether the copyright system is fit for the digital age and the green transition as well, and whether we should have a common and a more consistent system altogether.
Thanks, Jean-Marie. Then I think we've answered the questions that we've received then. So maybe then we'll just wrap up. And I think what Jean-Marie just said then is pretty pertinent. One, we don't think the system is fit for the digital age. It's not in line with Europe's digital agenda and the green transition. And secondly, the copyright levies are really a nightmare for the single market, for burdens, not just for manufacturers, but for importers and distributors, but also for all those SMEs and businesses who are inadvertently captured by this system, because they end up paying levies on the devices that they purchase for their employees, so laptops and printers, work phones, etc. And they shouldn't be paying them at all, but because the exemption and reimbursement systems are so fiendishly complex in Europe, many SMEs end up spending thousands of euros in levies on something where they're not even entitled to make private copies. And so we think reform is long overdue, and there are alternatives. And we also discussed today the Finnish model, which we think could be a blueprint for the future. So yeah, as I said, this is the start of our conversation. We would love to engage with you guys even more on this topic. Feel free to reach out to me. I'm Hugh Kirk. You can add me on LinkedIn or to drop me an email about this. Happy to discuss it in more detail. And we're also going to organize a physical roundtable in Brussels, I think in the new year as well, to have more of a discussion with policymakers. And maybe also just to flag this year, this Digital Deep Dives series continues. Next week, we have a really cool panel on cybersecurity with lots of interesting speakers. So if you haven't already signed up to that, also take a look at our website and sign up. So thanks a lot, everyone, for today. And yeah, hopefully we can stay in touch on copyright levies, and hopefully we can reform this system.
Thank you.
Thanks.
Thank you very much.
Thank you.